closer to just part of his website in a form of advertising. He was actually subjected to bar discipline for this post, in which he wrote a blog post about one of his cases. And this is why I say it's almost never a good idea to talk specifically about your cases and your clients, whether it's in a testimonial advertising using an actual name or in the form of blog posts. And if you read a lot of legal blogs, you'll see that bloggers hardly ever talk about the specifics of their own cases. And for good reason. I mean, in this case, Hunter was disciplined for it because he talked very specifically about what went on in the case. Now, as it turned out, he challenged that discipline, and he was successful, at least to one extent, in that the court found that he had his client's permission, and everything he'd written about was already in the public record. But I think he really, was more lucky than good in that case, and that he took a chance and he got lucky. They were really looking for a way to string him up on that, and it wasn't just because of the client's permission thing. There was also a concern that he was revealing stuff that was involved in the case that might have implicated co-defendants, et cetera. So there's stuff beyond just the own parochial interests of your own client to weigh into this, and that's why it's probably not worth writing about. Now, interestingly, in Hunter's case, even though his discipline for talking about the client was overturned, he was disciplined for not having a disclaimer on his blog. And this is something to think about when it comes to blogging, is whether your blog is really a blog where you're actively engaging in dialogue and talking about issues and your ideas, or whether your blog is really just a website in a form of advertising. And a lot of blogs are. I mean, you'll see a lot of legal blogs like this one I'm showing you here with the Reeves Law Group, where it's not a blog. It's just advertising. And in that case, you really should think about it as being a website, and thus it's going to be fully subject to the rules governing attorney websites, which means it's got to have the disclaimers, et cetera. And again, there's actually a lot of interesting legal issues around the intersection between the commercial speech doctrine and how it applies to blogs when you're properly thinking about blogs. I don't have time to get into it here, but I do it on some of my other webinars about the law of blogging. But just keep in mind that if your blog has a promotional purpose, predominantly promotional purpose, think about it as a website and use that lens when you're looking at your state's rules, because there are typically specific rules around disclaimers that attorney websites need to have, and they are specific to each state. A couple of final thoughts that are sort of outside of the attorney advertising context. One is embellishment. And